Hello, everyone. Welcome to the China Business Legal Navigator. The topic for the discussion today is the complex world of dual language contracts in China, strategies, pitfalls, and the role of translation. In the intricate arena of international business with China, dual language contracts serve as a vital yet complex tool. These contracts, drafted in both Chinese and a foreign language, primarily English, are designed to bridge communication gaps between Chinese and foreign entities. However, they can also be used strategically by Chinese companies, and the role of translation in these documents brings its own set of challenges. The critical nature of language in a dual language contract. In China, the Chinese version of a contract often holds greater legal weight. This dynamic has led some Chinese companies to employ a strategic use of language, presenting more favorable terms in the Chinese English version, while the Chinese version contains clauses beneficial to themselves. This disparity can significantly impact legal proceedings. A common issue arises when the English version of a contract um, states that it is the governing document, while the Chinese version declares itself as such. In such cases, Chinese courts typically prioritize the Chinese version. This can disadvantage foreign companies that have not thoroughly scrutinized the Chinese text. Pitfall 1: Translation issues in legal proceedings. A notable challenge arises when English contracts are used in Chinese legal settings. Courts or arbitration panels in China often appoint translators to render the English contract into Chinese. However, the translators may not always be proficient, leading to significant issues in litigation or arbitration. Disputes over translation can derail cases, shifting focus from the core legal issues to arguments about linguistic accuracy. Solution: to mitigate this risk, it is advisable to have the contract translated and reviewed by certified and experienced legal experts in China before any dispute arises. This proactive approach can provide a more reliable basis for any legal proceedings, reducing the reliance on court-appointed translators. Pitfall 2: Strategic misalignments in contract versions. Some Chinese companies might include favorable terms for foreign parties in the English version while embedding advantageous conditions for themselves in the Chinese version, banking on the latter being given precedence in legal disputes. Solution: conduct a thorough review of the Chinese version of the contract with the help of legal professionals fluent in Mandarin. This ensures that both versions are aligned and that no disadvantageous clauses are hidden in the Chinese text. Pitfall 3: Inconsistencies and misinterpretations. Differences in interpretation and translation errors between English and Chinese versions can lead to disputes and legal complications. The predominance of the Chinese version in legal context in China makes this especially problematic for foreign parties. Solution: employing skilled legal professionals specializing in Chinese contract law is crucial. These experts can ensure that both language versions of the contract are consistent, clear, and legally sound. Navigating dual language contracts in China demands an acute awareness of strategic language use, the critical role of accurate translation and contract drafting in China, and the nuances of legal interpretation. Addressing these challenges requires consistent legal clauses in both languages, comprehensive review by bilingual legal experts in China, and an understanding of the complexities of legal translation. By adopting these strategies, foreign businesses can establish more secure and equitable agreements, enabling them to confidently engage in the dynamic and often challenging Chinese market. Thank you for listening to the China Business Legal Navigator. Contact us if you need legal help in China, help with background investigation of Chinese companies, protection of patents, trademarks, intellectual property in China internationally, verification and drafting of contracts so that follows the law in China, and also legal translations to Chinese, help with trade issues or conflicts or IP conflicts with Chinese companies, etc. If you require assistance or have further questions about the services, please do not hesitate to contact the Customer Relationship Manager, Jan Erik Christensen at janerik@ncbhub.com, janerik@ncbhub.com. You can go and visit our website at ncbhub.com, ncbhub.com. We look forward to hearing from you and helping your business succeed and grow in China.